Okay, welcome everybody to Commercial Leasing Strategy for Success. I am your host, Stephen Wallace, with the Wallace Law Group. A little bit about us. We are a real estate business and bankruptcy law firm. We have offices in Boynton Beach, Miami, and Sunrise. We are founded in 2009. We have 3 attorneys and 3 paralegals. So here's what we're going to discuss today. Important make or break lease terms. We're going to talk about the nuances of CAM charges. We're going to talk about default provisions. What are they? Talk about personal guarantees and what effect do they have on commercial leases. And we're going to talk about what effect does bankruptcy have on a commercial lease, deal makers and deal breakers, and then we're going to have a question and answer period at the end. So let's jump right in. First section is make or break lease terms, part 1. It's important to understand, and one of the common questions that I receive from clients and prospective clients all the time is, do you have a form lease? And my next question is, what type of property is it? And then my next question is, how are the building expenses paid? Who makes the repairs? So in a nutshell, one lease does not fit all. So there's 3 different types of commercial leases. There's a gross lease, which is that there's no expenses passed through, meaning if you pay $700, it includes, the lights, the telephone, other utilities. There's no common area charges. So it's really, oftentimes we see gross leases on C or D type of properties, just because the landlord wants to encourage you to lease this property under, under the ability to pass through, to assume all the pass-throughs as it relates to the particular property. More common when you see the word gross lease, it's a modified gross, which means some expenses pass through. There will be some cost built in of the common area charges. And oftentimes the utilities like telephone, internet, water, electricity are paid by the tenant. The most common type of lease is a net lease, or some type of modified net lease. And you'll often hear the term triple net lease also when we're talking about these types of projects. And basically what that means is you pay rent and that amount goes to the landlord, plus sales tax. And then all of the other costs, there's usually a common area charge, which we're going to talk about, which is also known as CAM. And we'll talk about that more in detail shortly. And the real estate taxes and other costs, those are paid by the tenant. The other important make or break lease term in a commercial lease is who makes the repairs. And oftentimes this is a give and take. Who's responsible for the HVAC, which is the heating and air condition system, who's responsible for plumbing and electrical. And oftentimes, if the landlord is responsible for the HVAC and the plumbing, oftentimes there's a requirement that the tenant has a service contract on the property and or is responsible for the maintenance of these types of properties. Another important point, and this oftentimes companies are looking to expand or ultimately down the road have an exit strategy of selling their business. And as a result of that, the assignment and sublease provisions are extremely important. And so under those circumstances, when you're selling a business, that's a key section, because generally speaking, when you're selling a business, that's deemed an assignment under the lease. And I've seen many leases and many business transactions fall through because the landlord won't consent to the assignment of the lease to the new buyer. Another issue also is sometimes a landlord will agree to the assignment, but the existing owner remains liable for the performance of the new owner under the lease. And that's a deal killer, because if I'm selling a business, the last thing that I want to do is be responsible for the new owner's performance under a lease when I'm sold them the business. So oftentimes what you want to do is you want to negotiate those assignment and sublease provisions ahead of time, knowing that your particular client, especially if you're representing the tenant, they are looking to sell their business down the road. And the last thing we want to do is have a landlord put a wrinkle or kill the deal when a business is looking to sell their business. The next make or break lease term would be build out. What is the procedure? And this is assuming that you're taking an existing office space or an existing retail space or industrial space, and you want some improvements to that particular space. And so the first question is, what's the procedure? Generally, a landlord has to approve the plan before construction. And depending upon the nature of it, you may or may not be required to pull a permit. And it really goes to what the laws are in your particular municipality. The other issue would be whether contractor liens are going to be an issue. In Florida, where I sit, and in New York and Texas, where I also practice, there's a requirement under the lease that the tenant is going to make any improvements without any liens on the property. Because the issue is, if a tenant hires a contractor and then they don't pay the contractor, the tenant will be liable for breach of contract under the construction agreement, but also under a majority of state laws, if a contractor is not paid for tenant's improvement, they can actually lien the property. And so the landlord would have a lien on their property for improvements that were a tenant's improvement. So generally in the lease, there's a procedure where if the tenant doesn't pay their contractor's liens and the contractor liens the property, then it would be a default under the lease. And generally, if I'm representing a tenant, I want to give the tenant the ability, if there's a dispute, to bond the lien off, getting a surety to bond that particular property and bond that particular debt, and then fight the contractor, in court. So that's an issue that you always have to be mindful of. The other issue as it relates to build out would be a tenant improvement allowance. And how is this paid? And what I mean by that is, generally speaking, and we're going to see it now because there's a challenge in commercial leasing that we're already experiencing, especially in the retail and office sector, and it probably will continue on for a while, is that landlords need to attract tenants. And the way that they attract tenants is by giving them tenant improvement allowances. And oftentimes, there's an issue on who's going to be making the improvements. Is the tenant going to be making the improvements, or how are they going to receive the money, or is the landlord going to be making the improvements? So that's certainly something that will lead to a give and take when we're dealing in negotiation. The next issue is, does rent abate if there's a casualty, i.e. a hurricane? We see that a lot. And business interruption insurance. So this is a very hot button issue now. We are recording this webinar July 17th of 2020. We're still in the midst of the COVID-19 pandemic. And what we're seeing in this particular area is that a lot of insurers are denying claims for business interruption insurance as it relates to COVID. They're saying it is not an act of God. And one thing that I can tell you, the only people that are going to win in this particular scenario are the attorneys, because there's a lot of lawsuits for bad faith litigation as it relates to the failure for insurers to pay business interruption insurance as a result of the COVID-19 pandemic. So those are also issues to be mindful of. The other issue is utilities and electrical capacity. Depending upon the business, certain businesses utilize more utilities than others, like a medical office, a dental office, a dry cleaner. And that leads us right into the next issue, is always be mindful of hazardous waste. If you're representing a tenant, especially if you're doing office leasing, which I've done a lot of medical office leases in the past, how is medical waste being disposed? And so generally there's receptacles, and the last thing we want to do is have a tenant liable for a breach of the lease, if that's not provided for. And again, we talked about it earlier, there's certain types of businesses, and another type of business is auto repair or car washes, oil changes, oil change services, dry cleaning, as we mentioned earlier, and medical offices. So that's another issue to always be concerned of when you're negotiating a commercial office lease. The other thing is certain businesses need 24/7 access, and not just access to the building. Oftentimes in large office buildings that don't have a separate meter for electricity, they'll oftentimes shut off electricity and shut off the HVAC on weekends and after hours. So that's something you need to also be mindful of. You just don't want to have access to the building, but you want to have electricity and you want to have HVAC in that building. And oftentimes in large office buildings in central business districts, which may or may not exist anymore as a result of COVID-19, we're seeing that a lot of large landlords will charge a premium on after hours HVAC. And I know when I worked at large law firms in central business districts, we had to call the management if we wanted to work on the weekends or after hours. So that's something certainly to keep in mind. The other issue is a very common section of a lease is that a landlord will have a lien upon default. And that lien is an issue if you have significant equipment or significant build out in the property. The other issue is zoning. And the one thing you want to note is you want to make sure that that particular use is proper for the particular use of your clients. And there's also a lot of negotiation in a section of the lease for what permitted use is for the business under the lease. And the last thing you want to do is have a tenant sign a lease and then be held in default because they're outside the purview of their permitted use under the lease. Make or break lease terms part 3. So parking. Oftentimes in a retail section, in a retail project, there's oftentimes dedicated employee parking that's behind the building or far away from the office or the retail. And so one negotiation is you want to have, and especially if you're in a large office building, in the central business district, and oftentimes there's a garage element to it. One of the things that's always negotiated, I know when I worked at large law firms, would be that you'd have exclusive parking, and oftentimes the senior partners had very close parking spots to the elevator and the like, and I would park on the 50th floor of the parking garage. And being afraid of heights, it was always some type of consternation when I have to park all the way up top. So that's an issue. The other issue, especially if you're dealing in office or retail, is you want to also have exclusive customer parking in the parking garage or in front of the building or near your store or your office. So those are something that's also give and take, and landlords don't give it unless you ask for it, and sometimes you have to pay extra for it. The other issue is what are the insurance requirements that the landlord may have? And you just have to make sure that you can meet those requirements. Security, something certainly you want to make sure that the parking lot or the parking garage is lit and has safe parking. Are there, especially if you're, again, in a more urban setting, you also want to be mindful that there are security guards, and the office building or the retail has a roving security patrol, or there's, you have to gain access into the building, and it's a secure building. These are all issues that you need to be mindful of. The other issue is that as you're approaching the end of your lease and you may or may not be renewing the lease, you want to make sure that the landlord doesn't put a for rent sign in your window, because the first thing your customers are going to think is, oh my gosh, the company that I do business with is going out of business. The next issue, which we talked about earlier, was use is very important. So the first thing we want to do, and especially this is even more important in a retail scenario, is exclusivity. You want to try to negotiate in the lease, if you're representing a tenant, to be the example that I gave, the only Chinese restaurant in the shopping center. And if you're a landlord, you want to lease up your property for the highest rents possible. So you don't want to give exclusivity unless there's a premium in the, within the rent. You may want to consider it, as a landlord, because you want to have a vibrant tenant mix, especially in a retail setting where there's walk-up tenants. And the question that you may ask in these days, what is retail? Will retail survive with the Amazon effect? Again, one of the great things I enjoy about living in the United States of America is that we are inventive, innovative, and ingenious. So I have my faith in the American people that they will prosper, and they will come up with ways to make all these various businesses decide. One of the things that I always tell my children is the job that you have isn't in existence yet. And so keep that in mind. The other issue that you want to think about is, what are prohibited uses? And a good example of that would be that there's no gun ranges, massage parlors, pain clinics, medical marijuana dispensaries, all the bad actors. But some other prohibited uses that a landlord may put in a lease, or a tenant wants to negotiate, is that they don't want to have any fitness or gym facilities, or any movie theaters. And really the concern about all of those types of uses is they're very intensive as it relates to parking. And oftentimes when somebody's going to the gym or going to a movie theater, they just go in and out, and they don't visit other vendors or businesses in the shopping center. The other issue that a landlord always wants to stick in there is, a landlord has a right to relocate your business. And as a tenant, you don't want that. Because as I mentioned on the slide, it's location, location, location. Now, the counter to that is that you can negotiate into the lease, if the landlord wants to do that they have to pay your expenses. But if I'm representing a tenant, I've represented both sides on these commercial leases. I, as a tenant, want to maintain my location. But as a landlord, I want to maintain the flexibility of the center. And if somebody wants to pay a higher price for that particular location, I want to have the ability to move my existing tenant into a new location and get the higher price. Because again, this business is about making money. And this business is about getting the highest location, the highest price for your property. Make or break lease term, part 4. Is there a requirement to open? So if I'm a tenant, as long as I'm paying the rent, why should I have to be required to open? And if I'm a landlord, my shopping center or my office building is going to go under if you drive through there and every business is closed. Even though I'm collecting the rents, the prospects of tenants renewing leases or as a landlord obtaining new tenants is bleak if you have a shuttered shopping center, even though all the tenants are paying rent. And following that point, must a tenant continuously operate? And we're seeing this is a nightmare during COVID. So even if a landlord has a tenant that's paying rent, if they're dark, and that's the term of art in this business, then this again doesn't help my shopping center if I'm collecting rent but everybody's closed. And then following this up, and this concept may or may not be in existence anymore, the term anchor tenants. We're seeing a lot of challenges in the retail industry where a lot of large bellwether anchors are such as JCPenney's and other and other tenants are going through bankruptcy and maybe shuttering locations. But one of the terms that I would try to stick in if I am a tenant attorney or a tenant's rep is that I want to include in the provision that I can terminate my lease if one of the named anchor tenants go dark or they close their business. The reason is, again, I'm relying on walk-in trade. I'm relying on folks visiting these anchor tenants, and then by doing that, they'll come and patron my Chinese restaurant or my sporting goods store or whatever my chosen business is. Some other issues that are specific to restaurants or banks are drive-throughs. Certain cities prohibit drive-throughs, and certain neighbors don't want them. The other concern to have if I'm a restaurant, and I believe we're going to see this a lot more in the restaurant and the retail sphere, is that landlords are going to in essence be in business or in partnership with their tenants by offering some type of reduction in rent and obtaining percentage rent, which is a percentage of the profits of a certain business. And one of the challenges as a landlord is how do you get an accurate reflection of what percentage rent is? The other issue when we're dealing in a retail connotation is delivery hours. How are my vendors going to deliver my inventory to me? And as a landlord, you want to limit the amount of trucks blocking customers' access to your business. And then again, just talking about it, there's always, we see a lot of disputes and a lot of litigation under commercial leases when there's parking or blocking building access. So these are all issues that you need to keep in mind when you're negotiating a commercial lease. So now we're going to shift gears and we're going to go into detail of what CAM charges are, because one of the things you want to ask yourself is not only what the rent is, what the monthly rent for the use of your particular space, you also want to know what the common area charges are. That's what CAM means. And oftentimes these are very highly disputed. And so generally, when you're calculating CAM, you get a proportionate share of what the total building charges are, the total mall charges are, or the complex charges are. And generally, it should be calculated on the rentable square foot. So let's say you have a rentable square foot of 1,000 square feet, and the building is 100,000 square feet. Then you would have a 1% of the total. Your proportionate share would be 1%. And so generally, what do your CAM charges include? They include insurance, they include licensure, they include repairs, they include maintenance, they include utilities, they include trash pickup, cleaning services, real estate taxes, property management fee, legal and accounting expenses, master association or real estate or REA charges, condominium association fees, parking lot paving, signage. What should not be included? Capital expenditures, the cost of a new roof or HVAC on the building or the property, mortgage insurance and mortgage interest and depreciation, repair costs to other lease premises. The one thing to always keep in mind as a tenant is you always want to negotiate in your leases audit rights. You also want to have a cap on CAM increases. And what do I mean by that? I mean that you want to have a year-on-year cap on what the CAM charges can increase on. You also, so these are all the concerns that you have when you are talking about negotiating CAM charges.
Steve, can I ask a question?
Sure. If you could include it in the chat section, and then I'll handle it at the end of the presentation. Thank you so much.
Okay, not a problem.
The other issues now leading on, we've talked about CAM charges and we've discussed default provisions. So we're moving on to discuss default provisions. So generally a default provision is when a certain party fails to perform their obligations under the lease. And what do I mean by that? You fail to pay rent, you fail to repair, And generally speaking, when we're talking about this particular issue, a landlord will limit their obligations under their lease. So generally speaking, as a tenant, you have all the responsibilities under the lease. Now, the one difference is, and we've had another presentation, and we're going to have future presentations on evictions and defaults under leases. But generally, there's a difference between a monetary default, and under your particular state law, there will be different provisions as it relates to what happens in a monetary or non-monetary default. But generally, each party must provide a written notice of default and opportunity to cure. And for example, a 5-day notice for late rents. And then you want to contrast this notice of default with late fees. Generally, a provision of a commercial lease will have a provision where if you don't pay by the first of the month and the landlord doesn't receive it by the 7th day of the month, then there'll be late fees. That's different than a default. So just keep that in mind when you're analyzing these particular provisions. So the next step is a tenant is in default under the lease. So what are the remedies for a landlord under default? And these again are always negotiated. So a landlord have the right to terminate the lease and take possession, always through court proceeding. The worst thing you can do, and I've had litigation where a landlord just go in and change the locks. That's self-help, and that's prohibited under every state in the United States law. There's a proceeding that, for a landlord to go ahead and take back possession of the property. The landlord can release the property. They have a duty to mitigate damages. They can deduct amounts from security deposits owed. If a tenant fails to perform repair, then the landlord can perform the repair and charge a premium. They can sue tenants and guarantors for money damages or past due rent. What are tenants' remedies upon default? They could terminate the lease. They can sue for money damages. They can perform a repair and charge landlord a premium and set off. So the important thing I want to mention to you is, generally speaking, if a tenant doesn't pay rent, a landlord has, and that's the most common default, a landlord has 2 remedies. They have a remedy for possession, and in most states, that's a quicker proceeding. It's summary proceeding. And then they would have then they also potentially would have a count for breach of contract, and that's suing for money damages. And the remedy would be getting a money judgment against a particular tenant. And generally in most states, summary proceeding is anywhere from 5 to 10 days. So a tenant would have 5 or 10 days to respond to the lawsuit. And then in most states, the money damage count is just a regular civil action, and generally it's 20 or 30 days to respond. What I normally do is I'll recommend, when I'm representing a landlord in that particular provision, is I would split up the counts into 2 different lawsuits. I would have them file a separate action, and generally you can do it in the county court or a lower level court like the housing court or the municipal court, to seek possession of the commercial space, and then you can sue the non-performing tenant for money damages in the civil court. So that's just a strategy that I have, and again, not always just one size fit all in that particular scenario. So the other thing to keep in mind is, when you're dealing in a commercial lease, oftentimes a landlord wants a personal guarantee, and as a tenant, I'm trying to eliminate it or make it as limited as possible. For example, I want to only have it as long as the tenant is in good standing, that this particular personal guarantee will only last for a year or 2 years. And if I'm a landlord, I want to have this unlimited throughout the term of the lease. And then if all possible, if there's options under the lease, I also want to include that in options as well. And then the other thing to keep in mind is this a payment guarantee or performance, or both? And so payment means that you're liable if the tenant doesn't make the payments, that the landlord can go after the principals personally or whoever signed the personal guarantee. And then there's another concept of, if you have to make repairs and it's not done, then the issue is going to be for performance, and the particular individual has to do that. If I'm a landlord, I always want to ask for a spousal guarantee. If this is a franchise, I always want to ask the franchisor to also sign, the corporate entity to sign as a personal guarantee. Now, the one thing to keep in mind, though, is even though we draft as many provisions as possible to protect a landlord against a company bankruptcy or a tenant bankruptcy, once a bankruptcy is filed and you're in the bankruptcy court, in bankruptcy court, the judges have pervasive authority to discharge personal guarantees and rewrite personal guarantees. So as many times as you can to write prohibitive language in a lease, bankruptcy court trumps all. Another thought process is if it's a weak guarantor, you may want to ask for additional security. And then the other idea is to offset a weak guarantor with month-to-month or short-term leases, and then they have the ability, the tenant has the ability to earn rights. As long as they are in good standing, then they can have a longer term under their lease. As we talked about bankruptcy, so bankruptcy is always a fear for landlords in any type of economy. And what we're seeing now, there's a lot of indicators to see that, one of my other practice areas is bankruptcy law, and courts are hiring and ramping up staff in preparation for COVID-19 related bankruptcies in the fourth quarter of this year and moving on. So tenant bankruptcy is a fear, and it could tie up the property without tenant payment for a considerable amount of time. Also, Bankruptcy Code Section 365 allows tenants to terminate a lease while in bankruptcy. The ancient dinosaur blockbuster video, which a lot of you may not even remember, used this tool to restructure its company. J.C. Penney's and a lot of the other retailers that as we are recording this podcast right now, they are also going to be utilizing this technique to trim the company of non-performing locations. Chapter 11 bankruptcy is also a great tool because it allows a tenant who is behind on their rent to pay their arrearage over time. Now, the one thing to keep in mind, though, if the landlord has already obtained a writ of possession, and as we speak right now, many courts in many states are still under a moratorium of issuing a writ of possession. But if a writ of possession has been issued, but the sheriff has not executed such, then the landlord is entitled to relief from the automatic stay. And as a landlord counsel, and I've done this in the past, you still, just to get a comfort order, the last thing you want to do is as a landlord violate the automatic stay, because there's draconian penalties if you as a landlord violate that. You want to file a motion with the court for relief from the automatic stay and get a court's blessing to continue to pursue your eviction in state court. So let's talk about some deal makers. So in this times where we're envisioning that there's going to be some challenges for a landlord to lease up properties, and just the way business is being changed as a result of this COVID, where a lot of folks are working remotely. One of the deal makers as a landlord is tenant improvement allowances, a $20,000 reimbursement for tenants for build out, or what we're seeing now, a lot of landlords and a lot of tenants are negotiating, and I negotiated this in my office lease, was I want the landlord to just do the work for me. And before I occupy the space, this work needs to be done. Another great scenario would be free rent, which, we're seeing, a lot of advertisements, especially in lower level class types of projects, where you get free rent, 6 months free rent to come in. We want a cap on the annual increases of CAM charges. You want to have an exclusivity. You want to have signage. You want to have exclusive parking. These are all items that will really attract tenants and sweeten the pot to attract tenants in your properties. So now we've covered what we need to cover, and now I'm opening up the floor for questions. I already have 2 questions that I'm going to address right now. The first question is from Miss Mark. Are CAM charges in conjunction with lease payments, or is it a flat fee? That's a good question. So oftentimes, depending upon what the type of the lease is, if it's a gross lease, then the rental payment is inclusive of CAM charges. If we're dealing with any other type of lease, then you would pay a monthly rent to the landlord plus CAM charges to the landlord, which would encompass, the common area maintenance charges. So these are all questions that are very important, to ask for, especially when you have a tenant and you're evaluating, the true cost of what it's going to be. And the other thing to keep in mind also is on the rental payment and on the CAM charge, you're also going to be paying whatever your local amount of sales tax is. There's a big push in a lot of states to get commercial lease payments exempt, and especially in the state of Florida, there's still currently sales tax on commercial lease payments. And so the Realtors Association and CCIM and a lot of other trade organizations are pushing to get sales tax exempt from that. But in many economies, especially now, because a lot of local and state governments have really expended a lot of monies as it relates to COVID. So that the issue is that I don't see that leaving anytime soon. The next question is from Tiffany. 2 questions. Does insurance usually include hazard insurance? And the answer is no. You have to talk to your insurance agent, and generally there's liability insurance and also hazard insurance. So you have to ask that particular question. Next question is, what's my observation regarding renegotiating office leases due to COVID? I have done it with my own office lease, and I would encourage, again, it really just depends upon, how your business is performing as it relates to COVID. But what we're seeing, and we've represented a lot of clients in lease termination agreements or modifications of their leases in the last few months, giving particular spaces back. We will see. It's really the market, is going to determine everything. But one of the things that we're seeing is that a lot of businesses are reevaluating the use of their particular spaces. And so what I mean by that is we're seeing a lot of push for remote working, and we'll see how long that chooses. But then a lot of workaholics say, I have to be in my office to get my work done. So it's going to be interesting. We're seeing a lot of push away from, offices in central business districts. And we're seeing something that we're seeing in the 70s, where there's been a push away from the city, and, folks are moving back to the suburbs, and the residential market is white hot. We're seeing a lot of folks that are buying homes with larger home offices to conduct their business that way. The next question is from Liza. When a tenant has major renovations done, should the landlord request a lien release signed by the contractor? The answer is absolutely, because the last thing we want to do as a landlord is discover that there's a lien on our property for unpaid tenant improvements. So absolutely, and you want to also include in the lease that there's a default if there's a lien on the property, and give the tenant a certain time frame to get the lien released or bond the lien off. Next question, is the sales tax based on the good or services provided by the business in the commercial space? The answer is no. It's just based on the rental payment, and that would generally be the sales tax on the lease. Now, there's also another concept where a business is required to pay sales tax on whatever the sale of certain goods are. And depending upon the state, there's a variety of exemptions under the sales tax for certain goods or services. But when I was talking about sales tax, I was just talking about sales tax on the rental amount. Does anybody have any other questions? And if you're shy, I'm going to write in the chat section. You can reach me at my email address, which is the wallacelawone@me.com. You can visit me online at thewallacelawgroup.com. And then I would encourage you, I'm more than happy to share the PowerPoint, and then I will also give you a link. This presentation is going to go on our YouTube site, And so I'll provide you all a link to that presentation. And I'm going to send a survey around. So I'd love to hear your feedback on this presentation. And again, I look forward to seeing you on future presentations, and you all stay safe and have a great weekend.